Welcome to the Eating at a Meeting podcast. I'm your host, Tracy Stuckrath, dietary needs expert, certified meetings manager, certified food protection manager. I have searched the globe to find people and businesses who are creating safe, sustainable, and inclusive food and beverage experiences for their employees, guests, and communities. In each episode, you will find authentic conversations about how food and beverage impacts inclusion, sustainability, culture, community, health, and wellness. I know that sounds like a lot, but we're going to cover it all. Are you ready to feed engagement, nourish inclusion, and bolster your bottom line? If so, let's go.
Hey everyone, and welcome to another episode of Eating at a Meeting. And this is a special episode because this week it is Food Allergy Awareness Week. And I'm so excited to bring you a different conversation every single day this week, Monday through Thursday, about different topics that are related to food allergy awareness and safety. So my guest today is Ryan Gembala. He is an attorney with Dooley Gembala McLaughlin Pecora out of Cleveland, Ohio. And he's the chair of the firm's Food and Beverage Industry Practice Group, where he regularly consults on issues involving the legal liabilities of food allergens and represents those in the food service industry. Hello, Ryan.
Hey, Tracy. Thank you. Thank you for the opportunity to be here with you today.
Oh, you're welcome. And everybody, I met Ryan last month, right? At the Fair and Menu Trinfo Food Allergy Safety Summit. And I just thought what he talked about was really important for us to discuss. I've had attorneys talk on the side of people with food allergies, but I think, Ryan, your perspective is really important for members of the hospitality industry. I think planners as well as the hoteliers and restaurateurs to understand. So can you start by sharing a little bit of your background and what exactly does the Food and Beverage Industry Practice Group do?
Sure. So that's a great question. Thanks, Tracy. So I've been an attorney for 19 years, and my practice has evolved over the years to where it is with food safety right now, and particularly food allergens. So I kind of started my practice focused primarily on the agriculture industry. From there, I moved to agriculture and produce. From produce, went to food manufacturing. So it was agriculture, produce, and manufacturing. And then found my way to the hospitality and food service side. And so that's primarily where I sit now. I still do a little bit of all of that. But as the Food Safety Modernization Act came into vogue and some other things over the last decade or so, my practice is really focused on hospitality side food safety and allergen controls. And so what's a little bit unique about my perspective, Tracy, like you say, is that I don't focus as much on individual advocacy or Americans with Disabilities Act advocacy or legislative advocacy. My practice is representing restaurants and hospitality industry folks, hotels, dining services, food service operations, those kinds of things. And so the other side of that coin.
Okay. Well, and I think that's important because we have, if somebody's suing somebody, we're suing your customers. And I think it's really good and important to understand both sides of the question. And it just actually brought up something that I saw in a Facebook group the other day around celiac disease. And some people were like, well, they don't have anything to feed me. And then the thread started, well, then you can sue them because it's under the ADA. And you just can't go sue somebody because they can't feed you.
No, that's right. And look, that's a broad answer to a very complex question. The idea that, hey, if somebody can't meet my dietary restrictions or satisfy my food allergic conditions, that I can then turn around and sue them. That is not generally the case in either the restaurant industry or the hospitality industry. And in fact, I've got some cases today that I hope to have some time to talk about in the restaurant context, where the guidance should have been, we can't serve you here because of your food allergy. Now, there's some exceptions to that, Tracy, that exist in other kind of public settings. You might think of the Lesley University case as an example, where a university would be obligated to comply with things like the Americans with Disabilities Act, where they're requiring students to purchase a menu plan from them and then turning around and saying, well, I can't feed you despite requiring you to purchase a food plan. That's kind of a different analysis. And that's why I say that answer is too broad to apply to any particular factual circumstance.
Right.
I hope that answers your question without too much legalese.
No, I think it does. I mean, and then I know there's people that go out there and just sue for the sake of suing to get a result. And I know Mary Vargas, she really looks at the cases to make sure that it's going to make change, right? Not just for, I'm going to say ambulance chase for lack of a better description. But so from a food service perspective, can you explain the most common legal issues that might arise from allergen mishandling in the food service side?
Sure. So I think if you think about common legal issues, and in fact, this was a focus of the presentation, Tracy, that you were just talking about a couple of minutes ago from the University of Maryland. And if you don't mind pulling up a couple of my slides,
yeah,
speak to that.
Yeah.
So, like I said, I don't focus my practice on things like Americans with Disabilities Act or even Food Safety Act legislation in the various states. The reason that I don't do that is because it isn't something that comes up as frequently for me as do other more traditional, what I would call on the ground issues. The most common types of liability I deal with for my clients is what we call common law issues. And so those kind of fall into two buckets. One is what I call negligence style claims. You can see it on the screen there, I hope. But this is when an establishment is made aware of a patron's or a customer's food allergy. In other words, somebody comes in and puts us on notice that they've got a food allergic condition. And so I describe those in kind of common parlance as reactive claims, right? That's the idea that you're reacting to something that somebody's told you. And the other type of legal issue that I see often is more product liability style claims. And that's when you know of an allergen in your food and you're proactively trying to make folks aware of its presence so that they can guide themselves accordingly. And so those common law issues are the ones that I see most often in my practice.
Okay.
As far as kind of mistakes that I see in the hospitality industry, that the biggest things that I see are really, I think it's a function of people thinking that doing the minimum is doing enough on some of the trainings and the education and so forth. And so I've got a saying that I use with my clients. I've got a couple of sayings and you'll hear me use them today. But one is the concept of if you know it, you own it. And so what I mean by that is businesses, you've heard the expression corporations are people too, and that's true in politics. It's true in DC, but it's true when it comes to civil liability as well. What I mean when I say that is that all of our employees are deemed to be actors on behalf of our business. And so when one of our employees becomes aware of either a food allergic condition with a diner or a patron, or aware that there's kind of a latent allergen in a food product we're offering, once they know it, they own it. And if they know it, it's implied that the rest of our entity, the rest of our business knows it as well. And so what's important in my mind is making sure that those folks understand that once anybody on our team is aware of a condition, that our whole team is deemed legally aware of that condition, and that they understand to execute what I call the chain reaction, which is a circumstance where somebody receives that notification from a customer and they know how to alert the appropriate people on our side to make service successful and what specifically to do to carry out that service. And I can speak more about that if you want, or maybe.
I mean, and putting in the context of a meeting, right? A meeting planner is collecting the information of an attendee, asking dietary restrictions. And then we send that information to our event manager or catering services manager. So at that point, we've communicated to them. And so that property should then be on notice.
They're on notice. That's right. And the expectation then is that they're going to make their entire team aware of whatever dietary concerns or restrictions or allergies we have coming in so that they can appropriately provide us service, right? Because that's what we're paying for. And if they can't do it, that they're upfront with us and let us know that in time to secure some kind of alternative arrangement. If you think about it in the restaurant context, a lot of times the hypothetical I'll use is that it's a busy Saturday night in a small restaurant downtown, and there's people, all the tables are full. The bar is full of people waiting for tables. The lobby is full of people that don't have reservations, and the staff is going bananas trying to get everything done on time. And in food service and hospitality, we know on the staff side, there can be a lot of turnover, especially post-COVID. And so finding folks to fill shifts can be an issue. So we've got people running around like crazy trying to get everything done. And I've got a family that sits down in the middle of that dining room, and maybe mom and dad have had a few cocktails while they've been waiting for their table, and they forget to mention to the host or the waiter that they have a child with a serious food allergy. But they pull aside a busboy that they happen to see scooting through the dining room and say, hey, can you let somebody know that my son's allergic to shellfish before they bring the food out? And these are real life scenarios. These are the kinds of stories that I've heard from clients, horror stories in a way. Now we're counting on that guy, that busboy who's maybe been working here for a couple of weeks, to make sure that he knows how to execute the chain reaction and knows to make the night manager aware, or the host aware, or the head chef aware, or all three. And that those folks then, when they call out the allergy, that the line cooks and the servers know what to do, whether it's working at the separate allergen-free station, whether it's sanitizing the station they're at, it's getting the food ready, marking the plate in some way so you know it's an allergen plate, getting the food out of the kitchen as soon as it's ready, not leaving it sit back there where you have a cross-contact incident, those kinds of things. And so to tie it back, Tracy, to your hypothetical, I think that's the chain reaction, right? And notice starts with us. We pass it on to the event planner, and the expectation then legally on them is that they're going to pass it on to their team, because that team is responsible for honoring its contractual commitment to you, its legal commitment to you, and doing it in a way that's safe.
Well, and Joan just asked that question just to clarify, and I think he just did, is that then there is the obligation on part of this.
I see the question. It looks like the question there, I think, is whether it's a legal obligation that applies to the entire team or if it just applies to particular folks on the team. And so this is a great question, Joan, because this is one I deal with probably almost every conversation I have is, well, isn't it enough that the general manager knows, or all the management level employees have been trained on food allergens, or the head chef's been trained on food allergens? And the answer that I routinely give is that is not enough. And in fact, anybody that could be involved in that process, in the process of serving or caring for a patient, a patron or a diner that has a food allergy, needs to be trained on how to safely serve that individual. And so in that example I just gave, that's how you end up having busboys and waiters and other people roped in that you maybe don't think of as traditionally being responsible for having that kind of training. It's important that they have training. It's certainly at an absolute minimum to notify somebody else and get them over to the table, or get them over to the register, or get them over to the line. Best practice would be for them to have training on what exactly has to happen. There's another case that I have in my slide deck today.
You want to do that? Which
where
one?
That very thing. If you flip to I pulled some notes because some of this. So I will tell you guys, if you look at it's Atlantic Star Foods versus Burwell. Let me see if I can get a slide number for you. It might be slide 22. There it is. So this is what happened here. This is an unusual one. So typically when I do presentations like this, guys, let me tell you a couple of things. Number one, none of these are cases that involve my clients. These are cases that I pulled out of the public record. I try to find things that are relatively recent cases from the last few years that I can share with you, just because sometimes the courts have a better understanding of more recent legislative changes and things like that related to food allergens. But I will typically bring a series of cases where I've got 3 or 4 examples of how you're supposed to carry things out, how you're supposed to satisfy your legal duties to your customers. And then one case that is kind of the nightmare scenario where this is what you don't want to have happen. And that's the case in this Atlantic Star Foods versus Burwell case. This is my kind of cautionary tale. And I say that because this is a case where the plaintiff, the individual who was hurt by a food allergic reaction, recovered not only compensatory damages, which is the money damages he suffered for loss of work and hospital bills and things like that. But also he was able to recover punitive damages, which are damages that are designed solely to punish somebody, to set an example for them and for others that this kind of conduct won't be tolerated. And so what happened in the Atlantic Star Foods case is a bodyguard, a driver, and his client went to a fast food restaurant late at night for hamburgers. They'd ordered at the drive-through, and the client ordered, I believe, 4 mushroom and Swiss burgers. The bodyguard wanted something called a Frisco burger, and he relayed to the individual on the other end of that call box, a drive-through call box, that he was allergic to mushrooms. And the call box operator said, well, look, why don't you guys come on into the restaurant? And so they came in to the restaurant, and the testimony is that Burwell, who was the driver, notified the cashier that he was severely allergic to mushrooms, highly allergic to mushrooms. And in fact, the night manager himself testified that he'd heard that relayed by Burwell on multiple occasions. The counter worker acknowledged that he was allergic to mushrooms and brought the cook out. And the cook acknowledged that he'd heard also that Burwell was allergic to mushrooms and so forth. Ultimately, the cook had told him that that they would be able to prepare the burger that way, that it would be bagged separately and not to worry about it. Burwell had told the restaurant that he didn't want the items cross-contaminated. They told him it wouldn't be a problem. When the order was up, there was 1 big bag and 1 small bag. Presumably, the big bag had the 4 mushroom and Swiss burgers, and the small bag had Burwell's 1 Frisco burger, sans mushrooms. But that isn't what happened, as you probably guessed by now. He bit into his sandwich. It had mushrooms on it, went back to the restaurant to notify them, tried to make it to a pharmacy, wasn't able to do so without being unable to breathe, was taken by ambulance to the hospital, was treated and discharged, and the day later had to go back to the hospital because his condition hadn't improved, and stayed there for several days afterwards, ultimately lost his job and all the rest of it. And so what's interesting about that, and we'll talk in a minute about how to satisfy your legal duties, but in that particular case, Hardee's, the restaurant in question, had a policy that they were to inform patrons that they didn't have an allergen-free cooking environment, that there was a possibility of cross-contact, that food allergies can be fatal. That's part of their policy. And in fact, the instruction to employees in that case was that if patrons had a question about food allergies, that they were to be directed to the written policy, which was supposed to be posted, and that the employees were not to answer any additional questions about food allergies other than to direct them to the policy. Now, the general manager at that restaurant had food allergy training. He had the training, and this is bringing us a long way around, but I'm bringing it back to the question that Joan had asked. The general manager did have food allergy training, but this was late at night, and the night manager was on duty, and the night manager didn't have the training, as I understand it. And the general manager actually testified that what should have happened is the patron should have been told, look, we can't guarantee no cross contact. If you have that severe of an allergy, we would suggest that you eat somewhere else because we can't guarantee that we can produce this in a way that you want it, that's safe to you. And that jury ended up coming back, like I say, with compensatory damages for that individual. And as you can see there on the slide, $175,000 worth of punitive damages as well. Mm-hmm. And so that's kind of a cautionary tale. That's a cautionary tale for a number of reasons. But
right.
It illustrates the point that just having the general manager at a particular facility trained really isn't enough. These are the folks, those people, the call box operator, the counter worker, the cook, and the night manager, 4 people all interacted with this particular patron, and none of them followed the guidance that the general manager had apparently had, or at least the guidance that was consistent with their posted food safety policy, which was that we can't do this safely for you.
Right. So I understand, I feel like I'm echoing, that every single property is going to, a hotel or whatever is going to tell you that, right? That, hey, we can't do this safely. We're not a nut-free environment, or we're not a gluten-free environment. And they're going to say, don't eat here. So how do you get around that?
Sure. So that's a good
And I
question.
don't think get around it. How can the food service provider really do that service? Because with 33 million Americans having food allergies and it growing, that's a lot of lost business.
Yeah. So I think that's a great question. I think that I'll tell you kind of a funny anecdotal story that I think highlights the point. I remember the first time I traveled overseas, being a kind of a good citizen, I called my credit card company and I had said, hey, I want to make you aware of the fact that I'm traveling overseas. I was going to Italy at the time. And I said, so if you see some transactions in euros and so forth, I don't want you to be alarmed or flag it as fraudulent because I'm actually leaving the country and I'm going to be in Italy charging things, presumably. And the operator on the other end of the line said to me, no problem, sir. We're going to enroll you in our fraud protection program. You'll be protected. We appreciate you letting us know and all the rest of it. And I got to the airport and put my credit card in to park and it was declined. And so I used another card and kept going. Got through security and went to buy some food and my credit card was declined again. And so I used the backup card one more time. I sat down at my terminal and I called the credit card company and I said, hey, what's going on? My card's been declined. And they said, oh, well, you're in our fraud protection program, sir. I said, well, that's not very effective customer service, right? Yes, I'm protected from fraud in the sense that nobody can use my card, including me. And so that's not really a strategy to deal with that legal issue, right? And so I would tell you the kind of the same thing, Tracy, in response to the question you just asked. I think the days of being able to sustain, especially on the hospitality side where you've got events that we're not trying to turn 10 tables a night in hospitality, right? And typically with hundreds or thousands of diners per meal. And so the idea that you're going to run a successful business by turning people away with food allergies these days maybe it's not legal advice, it's business advice, but it isn't practical. And so when I talk to my clients, I tell them, look, we've got legal duties. We've got duties to warn, and we can discharge those duties a variety of ways. Whether I typically tell people if they're doing a menu board or they're doing a menu, certainly, right. I tell them, look, list out the ingredients. I look for we call them redundant safety features, but the idea is that one isn't enough typically because we direct our folks for best practice, right? And I typically talk about having it be a 3-step process. So I'll do an ingredient list in a menu or on a menu board. I'll do an icon, whether it's a clamshell or a fish or an egg or one of those old style glass milk cartons or whatever. And then I'll do a verbal too, right? That my waiter, my waitress, my cashier, my server is going to ask about food allergens live. And that's the way we discharge our duty to warn. Now, we've got it, like I say, the duty to react that we talked about, the negligence claim, the reactive kinds of claims that I discussed earlier. The other side of that is the proactive claims, the product's liability style claims, where we know of a latent condition in our food that we want to make people aware of. And so when I'm talking through that process with clients, Tracy, the idea, if you think of, so I graduated from the Ohio State University. I'm here in Ohio, and we're proud of our Buckeyes, certainly. And we've got a candy that's very commonplace here, though I think maybe is not in other parts of the country. They're called Buckeyes. The idea is it looks like a Buckeye nut. It's a chocolate-covered peanut butter ball, in essence. And so I use this as an example because if you look at the candy itself, at least from some angles, there'd be no way to know that there's peanut butter in it, number one. And number two, the name itself doesn't suggest that there's peanut butter in it. Yeah, thank you, Joan. Yeah.
They are good.
So that's an example of when we've got a proactive duty to warn, right? I don't have to wait for somebody to tell me they're allergic to peanut butter necessarily to make them aware that there's peanuts in this. And so that's an opportunity where some of the signage, the menu board listing out the ingredients, those things are more effective because it's out there. And the customers understand this. This is an important piece when it comes to assessing legal liabilities. We need to put ourselves in the best position we can be to defend the practices of our institution. And so the old saying's right? An ounce of prevention is worth a pound of cure. If we could prevent an incident from happening, certainly that's best practice, right? But if we can't, incident is nonetheless going to happen. We need to be in a position that we can defend ourselves to a jury, because when you walk into that courtroom, typically, if you're in federal court, 12 jurors, if you're in state court, in a lot of places, only 8. But they're going to be looking at the plaintiff who has a family member who is either sick themselves or worse off, deceased, and has a family member sitting there at one table. And at the other table is going to be our institution and the legal team. And most jurors are going to have an easier time relating to the plaintiff, to the party that was injured, because they're going to have a spouse or a sibling or themselves or a child or a parent that has a food allergy. And they're less likely to be saying, oh, poor hotel operator. Just, it isn't practical. And so we need to be in the best position we can to defend ourselves and understand that when it comes to legal duties, we've got a duty to warn. And then once we discharge that duty, the patron, the diner, has a duty to protect themselves as well. And I think that's an important piece that sometimes gets lost when we talk about this issue, that I'm not telling you that if you have 3 warnings, you're going to be able to stop every allergic reaction in your dining hall. I don't think anybody can tell you that. But what I am telling you is that's going to put you in pretty much as strong a position as you can be if you have to defend yourself from an incident that nonetheless happened. If we skip to, if you don't mind, Tracy, can we skip to the Crawford versus Marriott case? Because I think that I've got it at slide 21, I think.
Okay.
Yeah, but I think this is a great example, and it ties in the hospitality piece of this. And so what was happening here, and folks, this is an 11th Circuit case. It's from 2021. It's only a couple of years ago, but 11th Circuit's a federal circuit court of appeals. So this is something that would cover several states. That's a fairly high profile venue for something like this to get to. Okay. But what here, and this is an example of getting it right, by the way. This is an example where Marriott really knocked it out of the park, I will tell you. Nonetheless, there was a food allergy incident, but they did everything by the book, everything as I would have recommended or suggested. Again, they're not my client. This isn't a case I was involved in, but I think it's a really good example and kind of highlights some of the ways to discharge the legal duties that we're talking about. So in this case, Marriott was catering a banquet for the Revealed Life Church. It was at one of their facilities in Georgia. And the menu offerings were blue crab, stuffed chicken, salmon, and kind of a vegetable plate, I guess, for lack of a better word. Now, the church had asked Marriott if they had a chicken option without seafood in case there were folks that had a seafood allergy, and Marriott told them affirmatively that we can absolutely do that, but let us know how many you need, put in the request, and we'll make sure to have that available to you. The church did not request a single allergen-free dinner. There was a signed order form that reflected the orders for the blue crab stuffed chicken, the salmon, and the veggie. Okay, so now they've made them aware that they could ask for allergen-free, none were requested. In writing, they've relayed to the church precisely what's going to be served, and there were no alterations requested, no allergen-free option requested. Nobody saying, hold up, stop the presses. We need to get the seafood-free chicken available. Mm-hmm. On the event, the hotel confirmed with the representative from the church that there were no changes to the menu because of restrictions. None. So this is the same written menu that they've already had and they've already approved. And now we're doing a second verbal confirmation that there's no changes required. Now, here's where things get a little interesting. The church made its own placards for meals. It was kind of a sit-down meal service, if you like. And so the placards had folks' names and then what they'd ordered. Crawford, the plaintiff in this case, her placard said chicken on it. Now, remember, this wasn't produced by Marriott. This was something that the church had done of its own volition. She ate the chicken, ostensibly unaware that it had blue crab inside of it. Because of her shellfish allergy, she became violent. The court found that the presence of crab meat in the chicken was not open and obvious to Crawford, and then it wasn't disclosed by the placard. So this kind of gets back to the buck eye candy example was giving you. Having a placard that says chicken, even though it came from the church, doesn't disclose to a diner that there's going to be shellfish in the dinner they're actually eating. Now, that said, the court nonetheless found in favor of Marriott because they said, well, a duty arose because you had this latent allergen in a chicken dish. Marriott, you satisfied all the legal duty that you owed to this individual because of all of the redundant checks that you had done prior to the actual meal service. There's a There's a quote here. I wanted to read it. It says, this is from the court. It says, Marriott's agents communicated to the church's representative, Pastor Carter, repeatedly and in writing that the entree being offered was a blue crab stuffed chicken breast, and asked several times whether any guests had dietary restrictions. Marriott also offered a different seafood free chicken entree for anyone with a seafood allergy. There's no plausible argument that Marriott disguised its dish or misled or misinformed consumers of what was in its offering. And so that's kind of a classic hospitality example where you have a duty to warn of a latent food allergen, and you satisfied that duty. Nonetheless, somebody got sick, but you did everything that legally that you were required to do. And then at that point, the obligation becomes hers.
Well, okay. Now my question is, does the obligation become the church? Because the church is the one that was taking the registrations. And if they had asked, they didn't communicate that to Marriott.
Yeah, well, now you would like to think that the church, the head pastor, was it Pastor Carter, would have relayed to his patrons, to his flock, that these are the menu offerings. If you have an allergic condition, we can get you something else. We can get you a seafood-free chicken. Whether or not Pastor Carter did that and Crawford just didn't respond or ignored it or wasn't aware of it, I don't know. I would think, so if you think, so that's, your question, Tracy, is a little bit, it's outside necessarily, potentially, it's outside kind of food safety issues. And this would fall under, to my mind, a general negligence duty, what we call a general duty of reasonable care. And I would think that as somebody that's responsible for overseeing my congregation and organizing this event, I would have an obligation to relay to my members that are participating that there is either, well, probably both. Best practice would be both, but certainly that there's seafood in the chicken option and that you can get a seafood-free chicken option. You'd like to relay both of those things, and belts and suspenders would be having some kind of response saying, crab is fine or give me allergen-free. That's a lawyer's dream world.
No, and no, it's my dream world. It's my dream world too. Because it goes to show that, because the meeting planner is the one responsible for ordering the food, right? Yep. You're the voice to that attendee. And so, but that contract that you said where it was documented, it's called an event order or a banquet event order.
Sure.
And that's where it should be documented. So but that's the system that they're run on is so antiquated. So trying to get that information sometimes on a BEO is really challenging, but it's imperative to making sure that the hotel knows to do that. And you as the meeting planner are saying, this is what I'm ordering. Yeah.
Yeah. Now, can I talk about another case? I don't know.
Yeah.
Let me see if I have it in my notes or not. Oh, yeah. It's 23. It's the Bresnahan versus JJ Alpine. Okay. What I like about this case, Tracy, it's a fast food sandwich restaurant. JJ.
Can I interrupt real quick? Joan just had a question. Do you know, were the placards that stated the ingredients of the food served or menus with the ingredients? I think it was, do you know? The answer is no and no. The placards just said chicken on them. Now, those were placards that were made by the church, not by Marriott. And so that's where you would have liked to have seen something that said crab stuffed chicken, for example, as opposed to just chicken. The menu, whether or not the menu ingredients were listed by Marriott somewhere, I can't say. This was at a banquet facility, and so it wasn't kind of cafeteria style service in the sense that you'd have a menu board behind the food service area. I don't think if they handed out menus that had the various entrees and the ingredients lists, it wasn't referenced in the court's decision. I feel like it would be if that was there. Yeah. So I don't believe so, Joan. Well, and I think that goes, that's and it sounds like it was a plated meal and not a buffet.
Yeah.
And so that plated meal is probably when you go to a wedding, you get that little placard in front of you.
Yes.
It says,
that's exactly it.
That's probably what it was.
Yeah.
Yeah. Okay.
That's exactly it.
Ryan.
Yeah, no problem. And so the Jimmy John's case, this is a case where an individual was making a lunch order for her office, sandwiches from Jimmy John's. And she told the cashier, whoever answered the phone at Jimmy John's, whoever was maybe working the line that day, to omit Dijon mustard from her sandwich, which did not happen, as you can probably guess. She took a bite of it without looking at it. The mustard was there. She had an allergic reaction, actually to the point that it impacted her speech long term. She was on disability for some time, ultimately was able to regain speech, but a meaningful reaction to eating the Dijon that she asked not be put on her sandwich. What was interesting about this case, this is a Michigan case. It's about 5 years old now. The court there found in favor of Jimmy John's, and it reasoned that, look, she had asked that Dijon mustard be omitted, but she had not disclosed to them that she was allergic to Dijon mustard. And Jimmy John's had an allergen control plan. It included new gloves. It included papering over what they call the cold table for sandwich preparation. It included separate bagging and all those kinds of things that you would expect separate utensils, things you'd expect to find in a kind of an allergen control plan, part of executing your chain reaction once you're made aware that a diner has a food allergy. But in this case, she didn't identify a food allergy. She asked for what the court described as a preference. And the court distinguished a food preference request from a food allergy request. And what they found is they said at that particular location, apparently, they serve 400 sandwiches at lunchtime a day, and that 50 to 70% of those sandwiches contain some kind of modification to how the sandwich is served on the menu, and that the court found it unreasonable to think that Jimmy John's should have to proactively ask everybody coming through the drive-thru or coming up to the counter what their food allergies are, but that the analysis would have been different had she disclosed that she had a food allergy. That's you know it, you own it. In this case, we didn't know it. And the ingredients here are on the menu board that's behind the register. And as I understand it, it was on the menu board at the drive-thru box as well, so that you would know what condiments and so forth came with what sandwiches. Now, these cases, let me mention one other thing that I think is helpful. These cases, the Jimmy John's case, also the Marriott case, these were cases where the court found in favor of the restaurant and the hotel in that case, and had ruled that there wasn't enough evidence even to get the claim to the jury. That's an important piece of what we do, right? Because when a case gets to a jury, whether I do plaintiff's work, I do defense work. I've been doing this 19 years. I'm all over the place. And I tell all of my clients, whether it's an individual, a corporation, a mom and pop, or something else, I say, look, when it goes to a jury, all bets are off. I don't know what those folks are going to do. I don't know what they're thinking about when they're in a jury box. These are 8 to 12 strangers that I can guarantee you what they're doing, their jury service is at the bottom of the list of things they wanted to do that day. And it's just unpredictable to know how they might come out. What's important about these cases is that these institutions were able, by employing best practices, were able to put themselves in a position that the case didn't even have to get to the jury, which is the best spot you can be in. Some of the things that I talk about, I've got a do's and don'ts in my slides. We could try and through it quick if you want. I'm just trying to pull it looks like maybe it's at slide 13, but this is out of, I don't know if anybody that's listening knows Keith Norman, the executive chef at South Point Casino, but he's got a book called Allergen Awareness, A Chef's Perspective. And this is a section that I put together for him for use in that book. And this talks through, I've got 10, it's called do's and don'ts. It's really do's. I've got 10 different steps in here. I know we're getting a little short on time, but if you skip to the next slide, if you look at number 3, what I'm talking about there is training for everyone. And so it's that concept, if you know it, you own it, and know how to execute the chain reaction. So 1 and 2 were safe handling, 2 was separate prep area and tools. Those are best practices. Tracy, I know you and I have seen examples of that even just a couple of months ago when we were down in Maryland. But those things, you don't always have space to have a separate freezer for allergen free. And so there's things you can do to protect yourself that way. But training, if I were to look at these top 10 do's and pull a couple of them out that I think are important, training would be my number 1. This is the training for everybody. If you hear me say one thing today, it's that. The emergency medical devices, there's different lawyers have different ideas about this. I am somebody that's in favor of having things like epinephrine on site. That's typically the advice I give to my clients. Everybody's situation is different. I'm not saying that's hard and fast, but I like to be in the position to be able to say, if I find myself in front of a jury, that I tried to do everything I could to save that individual, including having a stock epinephrine. If you skip to the next slide, though, this is important.
On that note there, I'm doing an event at Lock and Terra Resort in Texas, in San Antonio next month. And that director of security said they have epinephrine on staff, and everybody on his team has been trained on how to implement epinephrine, I about jumped out of my chair and hugged him because I was so excited.
Yeah. That's never the answer we get, right?
It's not. And I'm like, oh my
That's
God,
good.
I love you. Yeah.
I know just in the couple of minutes we have left, I think number 5, when it comes to litigation protection, this is important. So I'll talk to you about things to document if you have an incident, probably in our last 10 seconds. But what I'm talking about here is documenting training and participation. So I like to train people when they're coming on board, and I like to do annual refreshers, and I want to keep notes of that. And it doesn't have to be anything detailed. It can be a log sheet that somebody signs that has the name of the training, safe auto injector use, and has a name and a date. And somebody signs in and puts the date that they had the training. It can be as simple as that. But these are certainly would I like you to preserve the training materials? Yes, I would. But my point is, these are the kinds of exhibits that you can put in front of a judge, or if you have to, in front of a jury, to say, listen, folks, this is something that we take seriously. Do we have menu that lists out our ingredients? Yes. Do we have icons? Of course. Did we ask? Yes. Now, the patron may say, you didn't ask me about food allergies. Well, how can we prove that we did? Well, here it is. It's part of our training, and you can see that waitress the last 3 years has signed in annually that she received the training. She knew what to do. Reviewing and updating training procedures is important, particularly where there's things like menu changes and that. If you can skip just for a minute to slide 17, which is number 9. This is a list of what I would call good or best practices if you have an incident that occurs at a premises where you're at. You're going to want to get a list of all the items that were ordered. I mean, certainly, I guess I've got some points there. You're going to want to get qualified medical assistance. So, if we have a epi on site, we'll inject, we'll dial 911, see what other medications have been taken. But things to collect for your lawyer or your insurance carrier would be a list of the food that was ordered, the identification of the people at the table and what they ordered, including alcohol, because that oftentimes plays a role, at least in a restaurant setting. Copy of the menu so we can see what was served that day and also how it was displayed. Because in a lot of states, these folks are going to have at least 2 years, possibly more, time to actually bring a lawsuit. And so how your menu looked in May of 2024 is going to be different probably than how it looks.
Yeah.
Get a copy of allergen notices. Is there something on the front door? Is there a posting at the host stand? Is it in the menu? Is it on the table somewhere? So forth and so on. Any written statements that were made, obviously you're going to want copies of those. If you can preserve the actual food itself, that's a best practice. Not always possible, but tickets, receipts, and surveillance, certainly the documentation, if you like, are things that you're going to want to preserve, and then call your insurance carrier or call your lawyer or whoever it is so they can guide you through the specifics of that situation.
Can I put a scenario in front of you real quick?
Sure, of course.
Okay, I'm going to say that 90% of the cards that go on a buffet are made by the front of the house staff.
Sure.
And they're made the morning of or an hour before that event. And I'm going to say 90% of the time, majority of those are incorrect. So, and those are in the back of the house. And I have been told by chefs, I make the food, I don't label it. And then the front of the house chef says, I don't cook. Right. They don't cook. So how would I know that? So from a hotel's perspective, and Joan asked this question, how does this become universal to make sure that these things, their method of communication, which you're saying as their attorney, should be standard practice? Yes. How do you think that happens, Ryan? Come on, Ryan.
Yeah, at training, right? I mean, that's the easy answer. Look, I recognize how difficult it is wrongly, but it is difficult sometimes to get clients to take food allergy seriously, in a way of taking it seriously up front. Everybody can react in a serious way to an incident once it occurs. But at that point, the horse is out of the barn, right? And I've dealt with that exact communication issue that you've just described as well. I've got 2 separate people doing it, and one's going like wildfire in the back, one's dealing with all the customers in the front. It isn't practical to think that they're going to find some other time to sit down and go over it. And the answer is you have to make the time. Now, in that instance, hopefully you've got those redundant safety features in place that your patrons are nonetheless protected. But understand this. Think about Hardee's. The Hardee's case, they had a policy in place. They didn't follow it. Compensatory and punitive damages as a result. So you've got a policy in place that includes placards on a buffet line as an example, and it's wrong. Right. That's a problem, right? That's acknowledging that you have a legal duty. It's trying to discharge it, but getting it wrong. Juxtapose that with the Marriott example where it was again and again, that those are difficult cases to defend for guys like me because it's not, you knew you had to do it and you just didn't do it. And if the answer is, well, they just didn't have time to communicate, that's going to be a tough argument to get past a jury.
Right. Exactly. Right. Joan wanted to know, and I do have your slides, but can I share the do's and don'ts with people?
Yeah. Do's and don'ts would be fine to share. They are in the book Allergen Awareness too, but I would definitely understand that this is not legal advice in the traditional sense. Yeah. Lawyers with our disclaimers, this isn't something that's going to apply to every situation, but as general ideas, these are things that I think are important. But I'd be happy, Tracy, if you want to share them with those that are interested, no objection at all.
All right. I'll put it on one sheet, have you proof it before I distribute it.
That'd be great.
Okay. All right. Awesome. So, all right. Anything out of what you just said, I just could talk to you for hours. What do you want people to get out of this more than anything?
Sure. Biggest takeaway to me is training everybody and documenting that you did it. Mm-hmm. That really is it. If I'm starting from that place in defending a case, I've got a pretty good base, pretty good foundation to build off of. Where folks haven't had training and there's an allegation that they did something wrong, that oftentimes that's a he said, she said, right? And it's hard to prove that one way or the other. And that's where jurors kind of look at the case and maybe they say, who do I like better? And that's not a place you want to be. So I think it's doing the training, you know it, you own it. It's training everybody on your team.
Okay, awesome. All right. And then my final question, and how do you may have just kind of answered it, but safe, sustainable, and inclusive food and beverage, a dining experience. How would you sum that up?
Yeah, I think that's it. I would sum it up by saying not taking the easy road. Tracy, to your question earlier, the easy thing to say is, well, I just can't serve you. And look, maybe there are certain circumstances where that's an effective business strategy. It is not for the clients that I work with. It isn't realistic to think you can turn away everybody with a food allergy or an intolerance or even preferences in some cases. And so I think the way to deal with that is to push the information out there in writing and verbally. It's the redundant features, and it's making sure that the folks on your staff, if they get pulled aside, even if it's not their table or not their line, or they're just in the dining hall, that they at least know, hey, this is important. Somebody disclosed an allergy, an allergic to me. Let me make sure I initiate the chain reaction and let somebody with more authority than me know that this happened so they can get everybody in line.
That's awesome. And it just makes me think, because typically on a banquet event order, it spells out the whole menu. And then at the bottom, it says 25 gluten-free, 10 no fish and whatever. And but you're not actually sharing with me what you're giving them. And that to me is not communicating clearly. Yeah.
No, I'd much rather have the entree described and the ingredient list and potentially the allergens too, though. Again, those are redundancies, but I would rather have one more line on an order sheet than have to defend a federal lawsuit. That's the truth. That's me.
I'm going to just clip that and quote it everywhere, Ryan. That is awesome. Joan just said thank you. And I know it's not legal advice. It's practical advice.
Yeah, that's right. Yes. Thank you, Joan. That's exactly right. Yeah, exactly.
Ryan, thank you so much. Oh, actually, and everybody, if you'd like to reach out to Brian, if you want Brian to represent you here, you can, if you need to, reach him at duleygembala.com. Yeah, thank you.
It was my pleasure. I really appreciate the time, Tracy.
Yeah, I really appreciate your time. And everybody stay tuned. Tomorrow, I've got a chef from the UK talking about how he makes safe food allergen meals with their 14 allergens that they have to regulate in the UK. So until then, stay safe and eat well.
Thanks for listening to the Eating at a Meeting podcast, where every meal matters. I'm Tracy Stuckrath, your food and beverage inclusion expert. Call me and let's get started right now on creating safe and inclusive food and beverage experiences for your customers, your employees, and your communities. Share the podcast with your friends and colleagues at our Eating at a Meeting Facebook page and on all podcast platforms. To learn more about me and receive valuable information, go to tracystuckrath.com. And if you'd like more information on how to feed engagement, nourish inclusion, and bolster your bottom line,
then visit eatingatameeting.com.